the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. The agenda, a couple of changes to the agenda. I had item 4C, which is a resolution of appreciation for Winston Sides. And adds item 7A, vehicles for dumping trash with Kirk Hildebrand. Are there any other changes to the agenda?
No, sir, I have none.
I can get a motion to
So
adopt as,
moved. Second?
okay. My motion made and second. All in favor, say aye.
Aye.
All right. Next item is the special presentation and appearances of the Business Spotlight. Tamika Walker, owner of Platinum Elite Beauty Shop. Come on.
Thank you. My name is Tamika Walker, and I own Platinum Elite Beauty Supply here in Orange, located at 119 Madison, North Madison Road. I share the building with Stafford Flooring there. We opened on March the 26th. We have recently decided to expand the beauty supply operation into an actual salon. So that will be coming hopefully by the 1st of June. Currently, what we do is we offer an array of beauty supplies, products for all ethnicities. We have shampoos, cosmetics, anything you can think of that you need as far as beauty supplies go there, we offer that. And again, we will have 2 to 3 stylists that will be in the shop once the salon actually opens on a daily basis. We are open from 10 to 6, Tuesday through Friday, and on Saturdays we're open from 9 to 4 p.m.
Very good. Do y'all have hair extensions? Because there's a couple of us.
I was going to
Yes,
ask
we
a better
actually
question. Do you provide advice? And then my next question was going to be,
We absolutely do.
There's not enough makeup in there.
So please come and visit us.
You do just retail, or do you supply any of the other businesses as a supplier?
We recently have a couple of the local hair salons
Okay.
that have come to visit us, so we are starting to supply the other
Okay,
local
all right.
hair salons in the area.
Okay. All right.
Just for people that may not be familiar with town, what other buildings might you be sitting behind?
We are located in the same parking lot as the Chamber of Commerce, so we are diagonal from the chamber in that same parking lot there.
Okay.
Thank you.
All right. Anybody else have questions? Thank you very much for coming
Thank you
by.
for having me.
Thank
you for
Thank
coming.
Okay. Next item is the consent agenda.
So moved. Second?
Any further discussion? Hearing none, all in favor say aye.
aye.
Motion carries 4-0. Next item is the adoption of the auxiliary list for the secondary 6-year plan. Mr. David. Oh, no, we're doing that after the 7 o'clock hearing, so let's go on to the award of the contract for environmental engineering consulting services.
Good evening. In February, we released a solicitation for environmental engineering and consulting services. We received 3 responses. After ranking them and interviewing the top ranked vendors in April, we are requesting to provide a contract to Joyce Engineering. They are very capable of providing consistent, high-quality professional services. We have several years of experience with them. The contract would be for 1 year with 4 possible 1-year renewals, starting in July.
Okay. Anybody have any questions for?
No concerns or anything? Everything looked good?
Everything's good.
They've been with us for how long now?
Long while.
What was that? I'm sorry.
12.
Okay. All right.
So moved. Second?
Any further discussion? All in favor, say aye.
Aye.
Motion
Thank you.
carries 4-0.
Once again, thank you, Stephanie.
Thank you.
Okay, next item is the trash and debris ordinance.
Wow, I came up fast today.
Are you awake yet?
I'm good.
We're on Amtrak.
I'm good. I'm still
line
getting everything
today.
loaded up here.
Why don't we,
I've got it up.
well, let's have Kurt, you wanna come up and kind of walk everybody through the committee meeting today, which gets us.
Oh, this was,
Oh, I'm sorry,
I put
I'm
him
sorry,
under
different
department
kind of-
directors.
I'm sorry, different track.
Different trash.
I'm good.
I'm just getting my computer set up, I was having technical difficulty, I'm sorry.
trash and then his trash.
It all goes to the same place.
Mr. Chairman, as you're aware, we had a couple of public hearings already and a work session on the concept of having an ordinance regulating trash and debris. What came out of the discussions was that we wanted to, at least in the beginning, we said we could start small and expand. And so I was tasked with reducing the scope of the trash ordinance. So what you have before you today is a trash and debris ordinance that deals with household garbage or furniture, appliances, other substances ordinarily and customarily located in interior of a dwelling. So basically what we said is stuff that comes from the inside of a house that you leave in your yard, that if it's causing a health and safety issue will become the portion of the trash ordinance that we enforce. And then I added language or modified the language to say that and if you've got household trash, it needs to be in approved containers. And then the other thing that was added was some discretion under the enforcement section for the county administrator as designee, that he can determine that as long as somebody's making good faith efforts to get it cleaned up, that he has the authority to continue or not act. And so I added some language that says that the county administrator's sole discretion determines that they're making good faith efforts. And as we talked about, we don't really want to go after these things. I mean, it's more the egregious cases that we're interested in. So those are the adjustments that I made. I stand ready to answer any questions that you may have.
One question, and it wasn't until just now that it hit me. There are a lot of people that will take household garbage and use it as compost. Do you see any issue there?
No, because I don't think,
I don't, I just wanna make sure,
Stored in receptacles designed for that purpose?
well, if you compost it, you get in the pile. I mean,
right, I just wanna make sure, because of, after the people we had speak and everything, I just wanna make sure that,
remember, it also has to affect public health, safety, and welfare. I
Right.
mean, we're not
Okay.
going after 2 bags of trash in a yard.
right.
What
Okay.
we're going after is huge piles of trash that are breeding ground for rats, snakes, whatever.
Okay, I'm good, I'm good.
I had a conversation with someone that asked another similar kind of question, I guess. We say in A, that shall permit to remain on the lot or parcel, and then we go on to say household garbage, furniture, and appliances. The question that was posed to me, there are people that have furniture on their front porch, refrigerators on their front porch, and things like that. How do we draw that line? And the distinction I think we're trying to make is that it's, removed from the residence and/or its patios and porches and decks and front porches and things like that, and literally on the property. And I guess my question is, do we need to say that any more clearly, or do you think that that's the intent and it's clear enough? I admit that I stumbled a bit when I was asked the question, because I hadn't thought of it. But certainly it's a real world situation. You see it, if you drive around very much, you see an example of what I'm talking about. And I don't think we're clearly not after.
No, what we're
that.
after is on the dirt itself, the parcel itself, as opposed to the structure. Now, of course, having said that, I can foresee where somebody's gonna complain about their neighbor's front porch. I mean, I can already foresee that, so I'm happy to add some clarifying language.
Which is what made me bring it up in the first place, was exactly the counter.
Well, let me, because I did write an administrative policy that hopefully, one of the key, I guess, thresholds reasonably liable to endanger the health of any person or injuriously affect public health or safety. So a refrigerator on the porch, or sofa, or something like that, I don't think in any, even the extreme is not going to endanger anybody's health or safety. Now, a field of refrigerators may be a different manner, so that's gonna be really the threshold, is can a reasonable person assert that this is injurious to the public health, safety, and welfare?
Well, and in your policy statement, there is you're getting it back to the board, so we're not relying on just anybody to do this. Everybody can have a chance to look at it, so I'm reasonably comfortable with that aspect of it.
Do you want me to kind of run through the overview of the policy?
Yeah, I wanted to do that too, because I got some more questions on that than I have on
Yeah, and
the ordinance.
actually, on the ordinance, the danger to health, years ago, refrigerators and freezers were made with locking doors. They're still out there. They're still out there. Once again, I know this is what people are going to come forward with. You know, the door's removed, the door's not removed, whatever. So I just,
There's a whole issue with at least particularly children entrapped in refrigerators, getting in, climbing in, closing the door, and then suffocating. And that's probably just a word of advice to somebody, that if I should come across them with a refrigerator on the porch, that kind of thing, securing the front
okay,
door.
I just, like I said, with the comments we heard and everything, I just wanted to
Oh,
make sure that we.
I mean, this is going to be a narrow line in order to do this. I'm certainly comforted by the fact that I make you all aware of what I'm aware of right out the bat, so.
All right, comments on the trash and ordinance enforcement policy? I have a question. Do we have any sense of how many we expect out of this? Because this is not an insignificant effort to go through this process. And I'm wondering how many we're talking about.
We had the tire matter not too long ago.
But that'd be a different issue.
Yeah.
The tires, there's actually state code provisions on. And then the tire's not a normally inside the house issue, so.
No, I'm just,
In fact, we just got a call the other day about, Josh called me to ask me, was this gonna address some neighbor who has 30 tires? I said, no, there's nothing they can do. This won't address that, and state law doesn't catch 30 tires either.
I can think of probably 15 to 20 properties that I know of that this will definitely address,
that,
which to me is not a lot, but it makes a huge difference in.
We'll probably see a surge in the beginning, and then hopefully people will.
When people figure out we're not playing the petty game.
Exactly.
Well, I can tell you the county of Powhatan adopted a similar ordinance, and it wasn't limited to the household, but it was a trash and ordinance, trash and debris in general, last summer, and I think they've had 8 complaints since last summer.
all right, I just want to make sure that we're not dumping, that we need you. Then the second comment I have is, in some places, you say, under items 5 and, under items 5, you say the county administrator and the director of public works, twice. Should that be and or?
You on the policy?
I'm on the policy,
Okay.
second page, 5 and 6, or item number 5. We say the county administrator and the director of public works. In some of the other places, we actually say and or.
And that was by design,
Okay.
I think. Let me, Mr. Frame, if I could, let me just kind of walk through what
Okay,
the
all right.
intent of this, and I'll answer that question. When you all wanted to see articulated a policy, how I would go about this, certainly I posed the question myself rhetorically, how would I go about this? And so really, there's an intake function, there's a due diligence function, there's an informal awareness made of the property owner or the responsible party, and then there's a corrective action plan. Let's work this thing out. And so I think each one of these steps should address that. Part of this process is anonymous, just getting, somebody makes a complaint, however it comes in over the door, over the threshold, and then we try to get as much information from that person. It's utterly unlikely we would get all this information, but at least we would make an attempt. I would then bring the county's Director of Public Works in, or other staff members, and Kurt's been given fair notice about this whole policy, so this is not a surprise to him. And he even had a chance to comment on it. But, the next part is, okay, what information about the property to know? I think aerial photography's come a long way, so you can actually track over time the accumulation of debris, most times if it's not under tree canopy. And then, as the board really wanted me to do, is to take that information, complaint, here's what we found out, and provide it to the Board of Supervisors. Then through you all, you're either gonna know the property owners and things, and then after you all have given me some feedback on that, and again, I'm not saying this is a lockstep 1, 2, 3, 4, 5 process, it could be 3 before 1, 2, that then I would contact the property owner or the responsible party as best as I can term it, just to let them know that we received this complaint and like to come out and take a look around, and like your permission and meet with you and do that. And then if they don't give permission, then I outline how this would work, I guess, in an effort to view the property, because I think whoever's made the complaint, we owe the obligation back to do some level of investigation. I don't know what I would do if I can't get anywhere to make an assessment of the property. But then I would say if I can't make an assessment either on the property or from an adjoining property, then it's not visible from a public right-of-way or adjoining property, so it's not a violation. Then,
On that particular one,
yes, sir.
in the previous segment, you say you'd take pictures. Would you
Right.
take pictures if you can't get on the property, but you can get at it from the road?
I'm gonna, most likely, but I don't wanna say I am.
Okay.
The fact that if I can take pictures from a public right at the middle of a road, appraisers do it all the time, of comparable properties and things like that, so I kinda use that as a.
I just say, you mentioned in the previous segment, but where you say you don't have permission, you don't mention the pictures. Okay.
And some of this is gonna be situational, as you
All
well
right.
know. Then if I've determined in my opinion, a violation has occurred, and the owner agrees that there is something that they need to correct the violation, then it's just a matter of working that out, and you do that in writing. And then, this is, let me back up here. I'm giving them in writing and advice of, we need to come up with a plan to correct the violation, and we give a date certain. I'm very big about dates, here's it, 30 days. We're gonna do something by 30 days. We need a plan in place. And then that's where, I think Kurt and I, instead of the and/or, I think it's a responsibility of mine to develop the correction action plan, but Kurt may be a little bit more, in the field than I would be. But I wanna assume responsibility, along with Kurt, in directly working with property owner, and so I don't wanna put that all off on the Director of Public Works. And then we, just like the tire violation we had, last year, we, eventually, we got it cleaned up and taken care of. If there is no compliance, there's fits and starts, and we're just not getting there, I've in the past have had people with violations like this, where they start out in good faith and then it just kind of falls off. Then decision has to be made to go ahead and bring the full enforcement of the plan, and then we would go into a formal enforcement mode. So it's a progressive, it's, I think there's a lot, every opportunity is given to the property owner to come into compliance, and we do it in an informal way, but then the formal way is there if we have to use it. Questions or?
So what was, I'm sure, not sure I understood what the rationale was, both you and the Director of Public Works on 5, as opposed to you or,
I'd rather have the ultimate responsibility
Okay,
with
all
the
right.
property owner. And let me give you a for instance, Mr. Frame. Mine may be a phone call to the person. Kurt may need to go follow up my phone call with a visit. And I'd rather have Kurt removed from having to make the phone call and the visit. I know that's not
So
not
he
real
needs the
clear.
best and you don't?
Well, we've already worked through the permission to get on the property. That's already been resolved.
all right.
One thing that, and maybe you were gonna mention this, Lee, but I think it might be a good idea, that in the ordinance, there be language that directs the county administrator to establish a policy. There needs to be some formal flag memorialized somewhere that alerts people, there's gonna be a policy. I don't know that the policy has to be in the ordinance, but it seems to me that a step in the ordinance language could include sort of the headline, by the way, the county administrator will be developing a policy or some such thing.
Well, do you want to add under 50-11 enforcement, whenever the county administrator or his designee, comma, pursuant to county policy, comma, determines that such an,
Yeah, wherever, I mean, I haven't really thought
something,
of.
I mean, something like
Just some,
that?
yeah, just that, just.
Let's come up with some words now so we can put this to
How
bed.
about something to the effect that the county administrator is to develop an enforcement policy for this ordinance,
Or an implementation policy.
implementation policy, and maintain such policy?
Okay, where are you
something like
putting those words now?
I don't know the crafting of where that goes.
I think it should go early in 50-11.
Yeah.
Tom's right, that's where it belongs. And it should be one of the first items there.
Pursuant to a policy established by the county,
Well, I think
pursuant
it's
to a
in-
policy established by the county administrator?
Well, and that's what I was suggesting, whenever the county administrator or his designee determines pursuant to Orange County policy that any such unlawful condition exists, or adopted Orange County policy, whichever you prefer.
How about if we have an A, the Orange County administrator is to establish and maintain an enforcement
And
policy?
then make the others B and C?
Yeah.
That's fine.
and-
Well, it's more than enforcement policy, it's a policy to implement the ordinance,
Enforcement and administration policy.
whatever.
Have we got the actual words for the record?
Yeah, why don't we do this, we'll make an A, it'll be 50-11, administration, semicolon, enforcement, semicolon, liens. And then A would read, the county administrator is to establish, implement and maintain an administrative policy for this ordinance.
Can you say that again?
The county administrator is to develop, implement, and maintain an administrative and policy for this ordinance. That's pretty simple.
Yep.
I mean, that's really all,
Okay, and that's A, and then the rest of this becomes B, or is that,
yeah, and the rest is.
B
what
is
is
on
A
the
The other
becomes
letters
B,
switch,
yeah.
yeah.
okay, does everybody understand that?
Wow, that exhausted me.
Is that the
I
motion?
didn't mean for it to be that bad.
No, but I
just being
want to get this off the agenda. I want to do something tonight.
I'm being facetious. I had to
Okay,
think through that.
all right.
Got it.
You're comfortable with that?
Good.
So if
Okay.
it's a motion to approve, it's a motion to approve with the recommended amendment.
Okay, do I have such a motion?
So moved.
Do I have a second?
Second.
Is there any further discussion? All in favor, say aye.
Aye.
No,
Okay,
I'm glad we got that, because frankly, we needed that in the ordinance so that somebody can see where they.
Okay, that's fine.
That's a good
I
ad.
just wanted to, didn't want to drag this out for another meeting if we could,
No, that's
we
fine.
could put it to bed. Okay, next item, Department Director's Constitutional Reports, item 7A, vehicle decals for dumping. Mr. Hildebrand.
Now you come up and talk trash on another day.
Prior to this meeting, the solid waste committee met to discuss enforcement, policing of how we determine who and who does not use our collection sites. Brief little history, back in 2009, the board adopted a resolution that basically stated decals would be issued to citizens of the county, and those decals had to be displayed for them to enter collection sites in the landfill. Shortly after that resolution was passed, there was further discussion at later board meetings because it was found that some citizens, primarily in the Lake of the Woods area, who owned houses in Lake of the Woods but didn't live there, became problematic for them to have decals. So then it was stated that decals are preferred, but in lieu of that, citizens could show driver's license as proof of residency or land ownership, or they could provide a permission to dump form, which comes through my office. And to this day, I probably sign 4 or 5 a month from folks that, for various reasons, don't want a decal, but want to use our facilities and our landowners. So, long story short, all that's been around since late 2009, early 2010. And over the course of time, I've reminded staff a couple times, but not recently, that it's part of the job of the attendants in the landfill to check to verify ownership of land or residency. Several months ago, I was made aware that we had a particular site that apparently was being abused by non-citizens using the site. So we did a little 2-week exercise and found that we did in fact have, in 2 weeks, 1,829 vehicles visited this particular site, and 35 folks were turned away because they weren't residents or landowners. So after the exercise, it seemed to me that I needed to once again remind all the collection site staff that, hey, it's part of our job to make sure that residents are the ones using these sites. So I reminded staff, look for the decals. If they don't have a decal, nicely ask them if they wouldn't mind getting one, because that's the easiest way for us to determine. In lieu of that, I said look for or ask for the permission slip or driver's licenses. I had no idea that it would create quite the turmoil that it has. And I have to admit that possibly part of it's the delivery of our collection attendants. Some of it I think is just angered citizens that they've been asked to get a decal. So I asked to speak to the solid waste committee to, one, find out if this is still the policy that we want to follow, and if so, what we might do to ease people's worries and concerns. So from the meeting today, I think it was determined by the solid waste committee that we should probably put something in the newspaper, a few newspapers to advertise what we're doing, remind folks why we're doing it. Potentially install new signage at the collection sites that clearly state, or more clearly state than what we already do, that these sites are for the citizens of the county or landowners of the county. Non-residents, non-landowners aren't allowed to use it. One thing I will say too that we didn't mention at the solid waste meeting today is that our permit, our landfill permit actually states that we're only to receive waste from Orange County. We're not a regional landfill, so technically we're not allowed to take out of county trash. I think DEQ understands that some slips in. I mean, it can't be perfect. We have to be diligent about trying to enforce that. So the bottom line is we want to continue to be good stewards of our budget and our landfill, but at the same time, we're not trying to upset citizens. So I think today I'm looking for any other thoughts the board may have that
One other thing that he didn't mention that we discussed was, this is a resolution, and we feel it probably ought to be in the ordinance.
Same ordinance you were just working on.
And so it becomes something that is,
Come to think of it,
Of a
yes.
We just two public hearings, 3 work sessions, and 2 meetings later.
And
Well,
we're going to amend it again, all right.
well, it just seems to me that a resolution, you know, 2 county administrators and 3 lawyers and 5 public works directors from now, probably nobody will even know that this is a policy, and we probably need to have it in a more permanent place.
And to add to that, that's kind of what's happened is some of our staff, have just, over time, have forgotten that that's, what we're supposed to be looking for. And they've forgotten that there were even decals out there, so the perception by some was that that policy resolution, was suspended or done away with. And it never was. It's just, we got a little bit lax in enforcing it.
And I think from the Waste Committee, we want to continue the policy.
The only question I have before we would do such a thing is, at the bottom it says, further resolve, the board hereby appropriates the funds for the decal in the amount of $11,000 from the contingency fund. I'd like to strike that from.
The ordinance?
Yes, inclusion of the ordinance. So.
Well, we may need to buy more.
Well,
But,
that's one of the issues I think we need to have a plan for, because it, you know, for whatever reason, people haven't been, some people at least haven't bothered to get those, and there ought to be a way to sort of facilitate some catch-up.
One thing is we need a better decal than what we had, because,
Well, we still
They're
have
crappy.
quite a few, we still have quite a few of the same.
yeah, but they
We don't
were,
last.
yeah, they fall off. I had one at one point.
well, the new ones, I will say, adhere better and do look better on the windshields. But if people currently have one that is still sticking to their windshield, they don't need another one, correct?
Correct. That's
So,
right.
we don't need to replace existing ones that people have unless,
And possibly that's part of the confusion, and I'll need
I,
to clarify. with our
I think
staff,
that
is
was a lot of the confusion, is people
Really, it's
replace
folks that
vehicles.
don't have any, that don't have a decal, we're asking them to get them.
And if somebody doesn't have a decal, they have a license, driver's license, which shows their residence. That's a valid proof of that. They have the permission slips, and I was suggesting for Lake of the Woods, they've got their, even for the people who live in Northern Virginia and have a house down here, they've got a Lake of the Woods ID card that they can use as a means of identification. So the whole idea would be a sign that says, okay, hey, only county residents, either a decal, driver's license, a permission slip, or, you know, and just basically letting people know that it isn't just a decal. In other words, decal makes it easier, you don't have to get out of your car and dig out your license, driver's license. But if you don't want a decal, that's fine too.
Well, what I was trying to get is there something we can or should be doing to make it easier for people to get those decals? Right now, what they're being told is, you gotta get in your car, you gotta drive to town, you gotta park, you gotta go into the treasurer's office, you gotta show documentation.
They should be able to get it from the attendants if they have.
Well, that's sort of,
But we did have some discussion about that, and even though we have law-abiding citizens working our collection sites, it opens us up to the fact of, well, somebody's selling bootleg stickers out of the collection site to people in Spotsylvania County or Greene County.
Plus, there's a matter of verifying
Right.
when a person comes into the site. And that's more easily done in the treasurer's office with that information than it is our attendees
Although I
without a
think-
computer, without anything.
Yeah,
I think the treasurer's office can make the job a little easier.
Yes, and we missed somewhat of a window this year because of the personal property, bills and then everything going out already and people getting stuff, but, absolutely, we do need to make sure that people can get them mailed to them or whatever. Any idea what the cost of
More than the decal costs.
Oh, I mean,
I'm pretty
no
certain of
question
that.
about that, so,
I'm thinking that, you know, if somebody needs a new decal, their old one pulled off, or they got a new car, they ought to be able to, contact the treasurer's office. And so if they're mailing them to them, they're mailing them to an Orange County address. Or some indication that the person is a county resident or county taxpayer.
we just need to make sure we appropriate the funds properly for that, right?
Well, I mean, from a cost tracking standpoint, the postage certainly can be, and I'm sure will be, attached to the landfill. And
Okay.
Anyway.
not knowing the volume of what we may send, I don't really anticipate it to be terribly significant. So I don't know that there'll be a budget issue.
Okay. Well,
I mean, there's probably quite a few out there right now because nobody's enforced it. People have bought new cars. And so we need to, but I think we need to make sure that they have an easy access. They don't have to drive into the treasurer's office. I think they ought to be able to get it by mail. And
Or email.
they can email and have the sticker mailed to them, yeah. Yeah. I mean, it's,
But we need, whatever the process is, we need to, in our advertisements or
Right.
communications with the public, we
Yeah.
need to say, here are the options,
right.
whatever they are.
well, we probably need to discuss with the treasurer's office because apparently there are multiple
Interpretations.
processes coming out of the treasurer's office.
Is there any way our website could handle
Sure.
the printing of a,
If we can make it a PDF, but then that doesn't make
then
it.
you
That
just not,
doesn't-
it doesn't, you can't stick it on the website.
Now we got back into black market
Yeah.
stickers.
Well,
Well, one thing to remember, I mean, I know when I go to the landfill, there's a sign there and it goes, this landfill is for Orange County residents only. That's on the top,
Yeah.
Right.
so.
And
And
just,
we did have signage at the collection site that was having the issue. But we elected to go ahead and put in a new sign and make it larger and make it more visible.
and I think telling people that, you know, how you can verify it. If they come up there, they're brand new into the county, you know, and maybe they can, you know, some way show. You need to prove it. Some people might use their electric bill or something like that. There's a variety of ways of doing it.
yeah, because you have a grace period of, 60 days before you have to register your vehicle and things like that. 60 days would violate the ordinance that we just passed a while ago.
And you know, in many cases, these permission to dump forms that I sign, a lot of them are new people coming into the area and they realize that they can't get a sticker yet, so they come in and fill out the forms. And some are just that they own land here, but they don't live here.
I mean, I don't think we're making an unreasonable request. I know one situation where you can't even enter the premises until you've cleared, there's a person at a gate. If you don't have sticker, license, whatever, you can't even
Right.
I think
get in the
Madison
place.
County was held at as, pretty stringent
Very
enforcement.
stringent. They actually issue to the property owners a mirror tag. If you don't have that mirror tag, you are not entering their landfill.
Whether you're a resident or not.
I don't care who you are. No, you're not going to be entering it. They're extremely strict about it. I would just like, I mean, it is a standing, situation that we've had for a number of years. We got lax in the enforcement of it, and I'd like for us to ramp it back up in the same manner that it became lax, basically. It is something we do need to do since we only accept Orange County, trash in our landfill.
And I think the fact that, you know, that's, we don't have to demand a sticker. We just have to demand proof of residency. And there are various vehicles for that.
Okay, so if we're going to put this resolution in there, what do we need to change to put that in the ordinance? Just the
Is there anything different in the resolution other than the fact that we'll appropriate $11,000?
Well, I'll draft it up into an ordinance form.
Well, what I will say is, if you read the ordinance word for word, it basically says that's the only means for using the collection site. Because it was after this ordinance that the board then said, okay, we have some other circumstances.
So we need to make sure the ordinance does give us a little more flexibility
Yes,
than the resolution.
I believe so.
Okay.
All right? Any further discussion?
One other thing, if I may add.
Surely.
Just appropriate, staff will put together what we propose to put in an advertisement in the paper. I was gonna suggest that we then share that with the solid waste committee at least before it's issued, or.
We can send it 5 people instead of 2.
Yeah,
Okay,
and just via email should suffice, shouldn't it?
Yeah, and the other thing is, if you ought to, I guess, authorize us to have a public hearing on this amendment.
Okay?
Well, somebody needs to make contact with the treasurer's office and work out the details of,
to
For the ordinance.
ordinance. I'm sorry, Tom.
Yeah, I think,
Well, why don't we do this, we'll come back with a draft, I'm getting ahead of myself, draft ordinance for you all to look at.
and discuss with the treasurer's office what is an appropriate way to
I was
distribute.
Jumping the gun on the
Yeah.
ordinance,
Okay.
public hearing, sorry.
All right. Thank you, Kurt.
Yes, sir.
Is there-
Okay.
Any chance we could do that via email or not,
For,
the draft of the ordinance?
I think send everybody an email initial draft.
Sure.
That way, we've already got it, and,
yeah.
We can digest it.
yeah.
is this something that we want to process for the next meeting? Or is that,
It would work for me, because honestly,
gonna
it's
look at the
something we're
count.
already doing.
looking at the county attorney on his workload, he's got a lot.
Oh,
going on.
I'll get it done in the next few days. I'll have it by
Okay,
hand by
then
next
we'll go
week.
ahead and schedule this for,
If we schedule it for the next meeting, we're not gonna be able to advertise in the
well,
ordinance.
no, this is just to approve, they're gonna look at the ordinance.
Not the public,
No,
not
no.
the public hearing at the next.
Right.
No, but
so-
we'll have an ordinance that we can then put out for a public hearing.
Then you
I mean,
can
I'm
authorize-
assuming I'll send everybody an email, and then I'll get email comments back if anybody has changes or
Okay.
questions.
And then we'll have a meeting of the minds at the next meeting, and then that would be an authorization for us to advertise.
schedule.
Sure.
Okay.
Okay?
Okey-doke.
All right. Next item, county attorney's report, amendment to the taxation ordinance.
Yes, Mr. Chairman, this comes at a request from the Commissioner's office. As you know, they currently send out every year a tangible personal property return that has your cars listed. And even though for most people it doesn't change from year to year, they still send one every year. And so the Commissioner asked me, are we allowed by law, which we are, to eliminate that requirement that she send one every year. She said it will save her several $1,000s in postage. So what I did is I redrafted the ordinance, and basically it said if the information is the same, because they get the DMV report as to what you own, if the information hasn't changed, they won't be required to send these returns to the citizens in the future. And so that's what this change is about, is to eliminate the need to send every citizen an annual return, tangible property.
But she would still send one out if she gets an indication of change from DMV?
If there's a change, then she would still be sending it out.
And she'll
Just-
reconcile that with DMVs.
Right, she'll reconcile that with I think it's all done internally in her computer system. And so, yeah, basically what it says is on any reports where none of the data has changed, she's not gonna be required by law to send. Right now, she has to send one even if all 3 cars are the same 3 cars as the previous year. So what this does is eliminate from her, which she said is the bulk of the mailings.
Okay, now if somebody disposes of a vehicle or a boat or something like that in the interim, she wouldn't know about that necessarily.
Yes, you would.
She gets a DMV report.
When you get rid of it, if you don't wanna keep paying taxes and everything, you have to go to DMV and get a disposal authorization, basically. They put it in the computer, it comes to our treasurer's office.
Or you can do it online. If you have a DMV
Right,
online
right.
account, you can just go online, say I've disposed of this vehicle on what date, and then she
Okay, so
gets a
that covers
notification.
that.
But if you don't, you're still gonna get taxed on it, believe me.
Well, I'm thinking, all right. I'm just thinking, I've got a boat that I might sell.
Well,
I'm
then,
not
in
sure that
order to
that would-
transfer the title, that person will need.
Okay, so okay, so the boat title is registered with the Department of Recreation
Or, game and inland
and
fish.
Gaming, all right.
And actually, DMV has taken over a whole lot of
Trailer.
things, streamlining a whole lot of the,
Okay.
If you dispose of it, I mean literally destroy.
It sinks.
It sinks, or it goes to the landfill, or something like that.
Salvage yard.
Then it becomes not titled anymore, and there's a
you have to
process.
do that, otherwise you will continue to be taxed on it. So.
Although a lot of people, I say, well, I don't own that car anymore, I'm not spending
well,
sending the taxes
when
in.
the tax bill comes, they'll find out they still own it legally.
We just had a situation where a gentleman had a motorcycle
Uh-huh,
and told us, well, I've been living in Arizona, so we'll show us your registration from Arizona. Well, I didn't register it while I was there. Like, well, no, then you still owe us the tax on your motorcycle. I mean, there's no documentation to
okay,
verify.
all right. Okay,
Learning from our,
Responsibility.
yeah, learning from our previous discussion, I think it's important that the last paragraph in A2 is something that we make people aware of. That, you know, if there's not a new filing, you're gonna get assessed and taxed based on the filing of record. So just because you're not gonna get a piece of paper doesn't let you off the hook. And they need to understand that that's gonna be the process, that the assessment and taxation of property shall be based on the most recent tax return previously filed with the county. That needs to be a headline that people understand.
You actually brought up one more issue. If the vehicle has over 100,000 miles on it, I believe there's still an adjustment made on it.
High mileage adjustment.
Right.
I think the documentation is, state inspection.
But I guess I see a potential problem here in that since people don't get that form, it's not going to click to them to bring that to the treasurer, which once again, even though it is their responsibility, we are here to serve the citizens.
There was, I saw from several localities where they would make if it was this age of a vehicle, then it was assumed to have this many miles on it to get
You
the
know
high
what
mileage.
assumptions do that?
But I think that's how the NADA, I mean, this is all based on, we actually have a contract, we download the NADA values. And I think the NADA book accounts for average, whatever it is, 12,000, 14,000 miles a year, when they value the vehicle. So it's the people that have excessive mileage, that have got 200,000 when the
but if
NADA.
you've got a 3-year-old car and have over 100,000 miles on it,
Right.
you should
Yeah.
see a reduction.
I don't know whether the chief commissioner does make an adjustment for high mileage.
Yes,
She
yes.
does. But you have to,
You have to provide,
state inspection or maybe a receipt from
No, it's-
a repair shop that shows. the
yes,
odometer
normally I believe the state inspection form
Has a mileage.
adequate for that.
is the correct accepted documentation.
And it has to have that high mileage as of January first, tax year, it can't have.
Okay, so they will still send it, if they see a change, either from the Game and Fisheries or DMV, they will send out a new one of those forms.
Understand technically what the law says, state law and our law says, what it technically says is, it's the taxpayer's duty to submit the information. All localities, because it's a whole lot more convenient, send the form to the taxpayer, and
I
say, if
know,
you have any
and
changes, sign it and send
When
it back.
when I went online, I'm saying, the registered owner of any motor vehicle, trailer, et cetera, shall file a personal property tax return. So I said, okay, let's go to the website and see if I can find the personal property tax return. And there ain't no such thing. So I'm saying, how does one comply with that?
Well, and what happens in every jurisdiction I'm familiar with, the commissioner sends you one and says
you
if this
validate.
is incorrect, and normally what they say is throw it away unless it's not right. I mean, send it back if it's not correct. And what the commissioner's saying is, on the repeats where the DMV report says nothing's changed,
They won't send it out.
we won't send it out based on the fact that DMV still shows you as owning all those same vehicles.
But it was just sort of interesting when I was looking at this, I said, okay, it says I'm supposed to file a form, and I couldn't find the form.
Well, maybe if we add something that, notice in the paper at the time that it would normally come out, a reminder, you won't be getting a form, one in the Lake Currents.
Well, I'm gonna put it in the Lake Currents as soon as we eventually pass this ordinance.
Well, I mean, one of the things that might be an option is to discuss with the commissioner, sending one last batch, and in those, putting a note, this is the last one you're gonna get unless there's a change.
That would be,
That's probably better.
yeah.
Notice is important here.
And that's, yeah, that's the big thing.
Okay.
But still a friendly reminder,
Oh, yeah.
yeah.
Does anybody have any issues with the words that are prepared here? Okay. So this requires a public hearing?
Correct.
Are we in a position now with these words to go ahead with the announcement?
There's no hurry on this one.
Huh?
There's no hurry on this one, so if
Okay.
you want me to talk to her first about notice,
Let's,
and
let's do that then, okay?
and then
all
I'll
right.
bring it back to you after I talk to her.
Okay, great. Anything else on this? Okay. Let's move on to item 9A. 1, 2, and 3, various speed studies.
Yes, sir. Mr. Chairman, members of the board, I'm gonna let Allison walk you all through this since she was the processed all these three.
The first item on your agenda is a speed study request for Route 696, which is Tyson Center Road. I believe that is located in District 2. The email from Ms. Smith is attached to the memo, but she explained in here that right now the road is unposted, meaning it's 55 miles an hour. There's a concern with the safety of children living on the road because of excessive speeds, and she is requesting that the board move forward with a speed study with VDOT. Do you want to discuss these individually, or would you
Let's,
like me-
since we've got 3 separate motions here, any
Okay.
questions on this?
I'm familiar with that road, and it should not be 55 miles an hour.
Is that the motion you're making?
That is.
That we do the speed study?
Yeah, that is my motion.
I have a second.
Second.
Any further discussion? All in favor, say aye.
Aye.
Motion carries, 4-0. Okay, next one.
And, the next one is Old Lawyers Road, is in District 4, and I've talked to Mr. Crozier about this. There's a letter attached from, a resident who is not only concerned about speeding travelers on the road, but, there's bus traffic that makes traveling a portion of the road, unsafe, as well as some deteriorating road conditions. There's some background information regarding previous requests that have been made. I did speak with the citizen, and he's not sure that a formal speed request was done. VDOT had looked at the condition of the road and provided some information to him, but no recommendations as far as the speed study. So again, this road is currently unposted, and speed limit is 55 miles an hour.
And with that, there's, if you read the letter, deputies have written tickets in excess of 76 miles an hour on this road. It's very common.
You want
And I so move that we authorize the speed study, and as with this, as with any of the others, really encourage VDOT to look a little more thoroughly than they may have in the past on some of the, we're not just frivolously sending these speed studies to VDOT. We have real concerns when they go to them.
okay, do I have a second?
Second?
Any further discussion? All in favor, say aye.
Aye.
Motion carries 4-0. Okay, the next one.
And the last request, the email mentioned several roads, but what I could get out of it was, a portion of, let's see, around Zor Road, from 614 to 611 out to Route 20, there's some concerns with hills in the road, speed. Some of the roads in that portion have already been reduced and are posted at 50 miles an hour, but this citizen is specifically requesting that Route 614, the Governor Almond Road, also be looked at for consideration of posting reduced speed limit signs. Again, it's currently unposted, and speed limit is 55 miles an hour.
I'd make the same motion again.
Okay, motion made, and do I have a second?
Second?
Any further discussion? All in favor, say aye.
Aye.
Motion carries 4-0.
What we would do is adopt a resolution. VDOT has a standard resolution for their speed studies. So I'll get those drafted, as well as a letter for Brian to sign. We'll send the speed study request to VDOT. I'll be in touch with each of the requesters and let them know.
Okay.
And then, of course, we'll circulate the full study back to the board
Okay.
once it's completed.
I looked at the letters from most of these people. There are some very good letters. I think our citizens provided good input on this.
Absolutely.
Okay, next item is board comment. Do we have anybody with board comment this evening?
Yes, Mr. Chairman, I have an item. It's come to my attention that we need to consider a text amendment to a section of our subdivision ordinance. There's a section that requires something called hydrogeologic testing that, frankly, among other things, gets referred to in several different places. There's an issue as to when that test is required and when it should be applicable. There's a fix that I've discussed with Josh. He might want to speak to this if he likes, that would make it applicable in situations where a preliminary plat is required. So we would tie the need for that level of work to those instances where there's a preliminary plat being required. So there would be a text amendment of some words in section 54-212 to hinge it to the requirement for preliminary plat. I might say that I'm not so sure that as part of the overall review that the subcommittee set up would be doing, that we look at this, because in doing a little reading about this, there are better options these days with new technology in terms of some seismic testing and the like that are a whole lot more accurate and better than poking a bunch of holes in the ground and having to plug them in a certain way. And it's if you've looked at that section recently, it's a very involved, expensive process that really doesn't even have good predictive results anyway. And so I think that's subject, at a later time, subject for revisiting the whole notion of that and replacing it with some newer technology options. But for the moment, the fix I would like to see us address is in the form of a text amendment. And there is some time urgency involved in this, so I would like to see us get a public hearing scheduled as soon as we can and move forward on it.
Don't we need the wording? Do we have the draft of the wording for purposes of announcing a public hearing?
I can provide you that wording if you would like. At least a proposed. Josh, you tell me if I get this right. The section 54-12 applicability would read it as follows. For any, and it says new major subdivision. Josh and I believe the word new should be struck because the definition of major subdivision carries the day anyway. So it would read, for any major subdivision, and then insert this, for which a preliminary plat is required.
which means 50 lots.
Right, according to state code, it means 50 lots. In a comma. So we'd add the words, for which a preliminary plat is required, comma. Does that sound about right, Josh?
That's the only change?
That's it?
I'm gonna pull it up on the screen if you'd like to see it.
Really, two changes. If we drop the word new, but that's more of a housekeeping thing, because a major subdivision is defined in other places. 212.
It's
212,
It's
I'm
Article
sorry.
8, it's Article 8, Alice.
I told you.
Right.
212.
There it is, 212. If we drop the word new, it would read, for any major subdivision for which a preliminary plat is required, comma. Then it would be served. by
Okay.
water, so.
All right, so that would be, well, that's, okay, so we've got the wording to go for a public hearing on that. Anybody have a problem with that? Okay, let's go ahead and, what's a good time frame for a public hearing to get it done? How soon can we do that?
Well, this has to go to the planning commission too.
All
So,
right.
what Josh and I discussed this today, what I would recommend is double advertise it. So advertise it for the first planning commission meeting in June. And then, actually the planning commission meeting.
This is the subdivision ordinance, though.
Oh, subdivision, I'm sorry.
No, I didn't think it had to go.
You're right,
It's just
you're right,
us.
you're right. I'm thinking about the other issue. Never mind. We had another issue we're talking about too. So.
This is just okay,
My apologies. Josh and I were talking about something else today.
this doesn't require a planning commission, all right? So how soon can we do this?
Would you like to do the May 24th meeting?
Can we get it advertised in time?
That would be preferable.
Absolutely good.
Okay, let's, all in favor, say aye.
Aye.
Okay. Board consensus to take this to
That was a long board comment, but it just it happened to be the.
hearing, May 24th. Okay? All right. Any other board comment this evening? Okay. Any questions on the informational items? Do we have any appointments? Are there any questions on the calendar? All right, could you read the words for going into?
Alrighty. Whereas the Board of Supervisors of Orange County desires to discuss in closed meeting the following: consultation with legal counsel pertaining to actual or probable litigation where such consultation in open meeting would adversely affect the negotiating or litigating posture of the public body, and consultation with legal counsel employed or retained by the public body regarding specific legal matters requiring the provision of legal advice by such counsel. And whereas pursuant to section 2.23711A7, such discussion of the Code of Virginia may occur in closed session, now therefore be resolved that the Orange County Board of Supervisors hereby authorize discussion of the aforesaid matters in closed session. Need that as a motion.
So moved. Second.
All in favor, say aye.
Aye.
Right.
You know, I was just being facetious when I said it exhaustive. It was just having a process that when you're
Allison, we
thinking.
do lock this room up when
Members of the board, to the best of your knowledge, were the only matters discussed in the closed meeting, public business matters lawfully exempted from open meeting requirements, and that only such public business matters as were identified in the motion by which the closed meeting was convened were heard, discussed, or considered in the closed meeting. Mr. White?
Aye.
Mr. Crozier?
Aye.
Mr. Frame?
Aye.
Mr. Goodwin?
Aye.
And Mr. Johnson's absent.
All right. Next item of business is the public comment. Do we have anybody signed up for public comment?
No, sir, Mr. Chair.
Okay, the next item of business is the public hearing on the proposed secondary six-year plan. Okay,
Mr. Chairman, I'm going to allow Ms. Simpson to walk you through the setup since she's the one that's been processing.
In the memo contained in your board packet, I just summarized what Greg Banks and I from VDOT had talked about since our work session. Mr. Tate is also here. He gave you the presentation at our April 12th work session. where he talked about some new funding levels, an overview of the current plan, and the recommendation to using some cost savings from some projects and new funding, we could rearrange some of the funds, but to leave the plan as is at the time, understanding that the plan has to be fully funded by January 2018 as well. There were some questions during the work session about the Gordonsville Gate subdivision, portions of roads in that subdivision that the board has a desire to turn over to the state system, and we did research. Gordonsville Gate subdivision goes back to 2005, and the subdivision has to be in use. The roads in the subdivision have to be platted, recorded, and in use for 20 years in order to be eligible for use of the rural addition funds. And the age alone is going to prohibit that development from being eligible. Lastly, we talked about not adding any more projects to the plan. If we did, we would pull it from the auxiliary list. When you hear your presentation from Mr. Banks or Mr. Nesbitt, they will review the draft plan, which is in front of you. It has our most current funding projections, and you'll see on there that the River Road project has been removed because there were highway safety funds that were used to complete that project. A portion of Old Office Road from your auxiliary list has been added to the plan, which Mr. Banks can go over. And lastly, the two roads from Flat Run Court and Rapidan Run Court were added to the plan. The use of rural addition funds was previously approved by the board, and in order to transfer those funds from rural additions to the projects, we've added it to the plan. So that's what we have as of today. Do you have any questions before you hear from VDOT?
No? Any board members have any questions for Allison? No. Any questions for VDOT? All right, let's open the public hearing. Now, we have any speakers signed up?
No, sir.
And let's close the public hearing. Okay. Any discussion by the, any further questions by the board?
Actually, I do have a question.
Sure, okay.
It says that everything will be fully funded by 2018. Yet, like, and I'll use Meadows Road, it's showing the money's in there 2020 and 2021. Just doesn't compute for me yet.
Sure, and I understand exactly what you're saying. It can be a bit confusing. The projects that are shown in the plan as of January 1, 2018 have to be fully funded within that plan, within the 6 years of that plan. So we will have one additional update prior to January 1, 2018, which would be next year's. Within that plan, you'll see fiscal years 18 through 23. At that point, they would be fully funded. It's not through 18 years.
Okay, that's where my confusion is.
You're not the first one to say that. I can understand where that
Okay,
confusion would be.
that makes a whole lot more sense when we were told that the money wasn't there. How is it gonna be fully funded all of a sudden?
Understood.
Okay. not
And
a
if you
problem.
look here in the draft plan, Old Office Road is the most recent piece here. You'll see there's a balance to complete of $390,000 beyond the life of this 6-year plan. If you turn back over here to the cover page, fiscal year 22, we're receiving about $475,000. So if we receive that again in fiscal year 23, it's pretty logical to believe it would be fully funded by that time of January 1, 2018. Plan date.
Any further questions? Can I get a motion?
So moved.
Second?
Any further discussion? All in favor, say aye.
Aye.
Motion carries 4-0. Okay, now let's hit on, go back to, before we go to the next one, let's go back to the adoption of the auxiliary list for the secondary roads. It's the one that's got Flat Run on it.
Thank you, gentlemen.
Thank you. Thank you.
The auxiliary list?
Any questions? Go ahead, Allison.
I'm sorry. As a reminder, we typically review the auxiliary list in line with our secondary six-year plan each year. Now that we've adopted that plan, it's appropriate for you to review this. As I mentioned, the entire portion of Old Office Road was previously listed on our auxiliary list. What I would suggest doing, in addition to anything else you wanna consider, we can adjust Old Office Road on the auxiliary list based on the portion that has already been added on your six-year plan. So we would just reduce the scope of what's on the auxiliary list, and reduce the length of, the project to update the auxiliary list. Flatburn Road is also on there, from last year, so, I think that's it at this point.
When you
can-
say adjust the scope of the Old Office Road,
Yes, sir.
what are you meaning by that?
When you look at the draft secondary six-year plan that's in front of you, the project that they added was, 1 mile. So Old Office Road is 3.3 miles total in length, and they have added a 1 mile section to
So
the
this should then be
six-year plan.
2.2 miles? if we-
Yes, sir, it would be reduced to 2.3 miles,
2.3.
to the length. And once, this project is closer to being fully funded, the board will have to make a decision, on which end of Old Office Road you want to address first.
Okay,
So we can make the change to this just by reducing the length. It's already in the plan, and then future decisions will have to be made about which section of Old Office Road you wanna do first.
okay. All right. Any more questions for Allison?
This does not bind you for a year. You can make changes to the
Understand.
auxiliary list at any time.
Understand. So with the change of 2.3 to 3, or 3.3 to 2.3 on the length of Old Office as a modification, can I get a motion?
So moved.
I have a motion, do I have a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Motion carries 4-0. All right, the next item is the proposed amendments to the zoning ordinance.
Gentlemen, you have before you this evening a, somewhat of a rewrite of Article 2 of the zoning ordinance. That's the administration section. If you recall, I think roughly a year ago, I had presented some potential ordinance amendments for the board to consider and prioritize, and submittal requirements were one of those. So we're finally getting down that list. And really, the intent of this is to clear up a lot of this language, if not all of it, was written in 1996, and obviously over time, things progress, practices change, and the intent behind most of this language was to align our current practices with our code, to take out a lot of that ambiguity that currently exists. So I guess at that point, I'll go ahead and open it up for questions. I know this is a pretty sizable amendment, so please feel free.
There, in two places, and unfortunately, I thought I'd marked it, but it didn't pop up. You're asking for, you're describing the contents of various site plans, and it ends with, it ends with the phrase, here's one example that I found. I'm in section 70-118. I'm under C17. And it's, I think it's in the next section. Yeah, okay. It goes through the list of things that need to be, that are called contents of the plan. And then it has item 17, any other information as may be required by the zoning administrator to evaluate the plan. I guess that gave me a little bit of pause, because one of the things I think we want to be trying to do here is introduce some predictability and consistency and understanding. And I guess unless it's absolutely necessary or you have some specific items in mind, both in that section, and by the way, it's item 14 on the next page, it's the same language, I think. I just, it would be, in my opinion, it'd be preferable not to leave that gate open unless there's some things that you can tell us about that you know need to be there or and the like. I just, it's not a big deal, but it's one of those things that caught my attention.
I could see that. It's one of those things that might not be a big deal with me personally, but a future zoning administrator might have a different take on that for sure.
Well, I guess I would say that if the items that could fall under number 17 as an example are minor, an informal discussion or negotiation could work that out, I would hope in most cases. If they're significant or repetitively needed, then we ought to spell it out and put it there. I just don't like, as I said, I live on a farm, you leave a gate open, you pay the price. I don't like leaving gates open. To me, that's an open gate.
Honestly, I think this was more done as a checkpoint information, because if this goes forward as adopted, obviously we're gonna produce checklists for plan preparers to make it easier for them. But I think elsewhere in the ordinance, I think it covers that in some way, shape, or form, so I would say if the board doesn't wanna see it in there, we can certainly remove it.
Yeah,
It's more desirable to not see it.
yeah, the other reference is in section 119, and it's item 14, which I think is the same language.
It is.
I'll point out the other substantive change deals with the Board of Zoning Appeals and the issue of
Let me,
special
before we move
exceptions.
on,
Yeah,
do we have a consensus to delete section 118, item Charlie 17? And on, and also on the next one, which is,
70-119.
yeah, 119, Charlie 14. Is that a consensus to just, okay, all right. Just make sure we understand what we're doing here.
Yeah.
Go ahead.
I was just going to actually point out that the other substantive change, I think, relates to the Board of Zoning Appeals and the issue of special exceptions. I believe that those are appropriate changes. I understand they're fully compliant with state code with respect to BZAs and the BZA functions. It appears to me that your language there has moved those responsibilities essentially back to the board and away from the BZA, which I think is an appropriate move. So, but I point that out simply because of the significance of the change.
Any other comments or questions? Okay,
I will touch on one thing here.
Sure.
It's kind of a curveball that the state has thrown us. I'm sure you guys have read the new proffer law. It's gonna come into effect on July 1st. That would impact the proposal under,
7193.
Item F.
yeah, starting under Division 7 and the provisions under there. Tom has prepared a draft to basically take this amendment language and replace it in order to be consistent with state code. So I was gonna actually pose the question to you gentlemen. We can either proceed with it as is and then come back in the next couple of months and do another amendment, or we could take
By
it.
July 1st.
Well, the new law takes effect July 1st, so I would prefer that we have, what I've drafted for, I just sent it to Josh this week, what I've drafted is, the new proffer law only applies to residential So what I did is I bifurcated our proffer ordinance, and I have a residential section and a non-residential section. And in the non-residential, we can take cash proffers and anything else. And in the residential section, I worked very hard to protect us from the law.
Notice she's writing that one down.
But would we be better off to come back for that prior to the 1st of July?
Well,
Or,
I told Josh, my attitude is we're already advertised, we're gonna have to advertise again anyway, so, you know, as far as I'm concerned, I'm perfectly content to adopt this one, knowing that.
Just
there's-
repeal it for now, and we'll pick it up later.
No, go ahead and adopt. it.
Adopt this, knowing that you're gonna see a section 191, or the conditional zoning, you're gonna see a new section before July.
Okay.
Or by virtue, if it stays in place, it becomes moot, invalid because of the state law.
No, here's the problem is, no, we can still, I mean, this
Oh,
one,
there's
this
the
one's
whole-
fine. But
I'm-
the whole, did we suggest a
Got it.
proffer?
Yep.
The one I've drafted for Josh to look at, and he's making some amendments to it, but the one I've drafted for Josh, one of the things it literally says is that nobody in the county has any authority to suggest, recommend, propose, or even discuss proffers with you. And so that's actually one of the things I've put in there, that's what I'm saying, trying to protect ourselves from the state law.
Got it.
And so basically what I did is I took the most terrifying sections of the new code section and did what I could to protect us from them.
Okay.
Proceed with the understanding that we'll probably be doing this again in a year, because the General Assembly will probably amend this again in 12 months, or
Yep.
6 months or so.
Yeah, the home builders didn't realize what they were pushing through. And there's already, the home builders, I've talked to several, oh, that wasn't what we intended. Well, we don't care what you intended, we care what was passed. And so there will definitely be changes this fall, because at the local government attorneys conference, the recommendation was, it's kind of a funny phrase, they used massive resistance. And several localities have already gone on record, we're denying everybody for everything. We're just, from here until whenever, we're just denying.
So the law has
zoning.
changed, yeah.
Because you're not gonna be able to mitigate your impacts without proffers, and we're not taking proffers, and so we're just gonna deny you. And so there will be, Josh is right, there will be a change, but we gotta
protect ourselves.
protect ourselves after July.
Sure, okay. All right, any further discussion? All right, we'll open the public hearing. Anybody signed up to speak?
No, sir.
Close the public hearing. Any further discussions? Can I get a motion?
So moved.
I have a motion, do I have a second?
Second.
And I have a second. Now, for any further discussion? And that's the motion to approve as presented, minus those two areas that we scratched out. All right. All in favor, say aye.
Aye.
Motion carries 4-0.
Thank you, John.
Do you want to do a separate motion about your minor site plan fee?
If the board's agreeable to it, yes.
Which is this now?
The motion on the $250.
Oh, yeah.
For the minor site plan fee.
And just as a, just to give you some perspective, our current major site plan fee is 400.
Okay,
By way of discussion, for reasons Josh will understand, I'm hoping at some point we can get away from terms major and minor and come up with a better phraseology, because those are,
all right.
but for the moment,
Since we just approved the, we had the public hearing on the previous zoning amendment, it would seem that we need to have a public we need to conduct a public hearing on the second part here.
is
So,
that the fee? I don't, does
All
that
right.
require public hearing? for
okay,
that?
For the planning and zoning fee schedule?
Yeah, we didn't advertise that, did we?
I wasn't aware that we needed to. I thought that was
I wasn't aware
administrative.
that we needed to either.
Yeah, I mean, we didn't advertise it, so, but it is technically part of the zoning ordinance.
But does the fee need to be advertised?
Was it
because
in-
of that?
I would think the fee needs, I mean, if we don't advertise a fee, somebody could argue that we didn't have notice, I would've come and spoken against it if I known it.
I don't know that it was ever, because the current one is dated from 2012, I don't know that they ever had a public hearing on that. It was all administratively adopted, because it's a separate document.
We should have had a public
I
hearing.
was gonna say, in that case, it's probably more important that we have a,
Well, what I would maybe suggest is that we do all of our fees and just re-adopt them all with a public hearing.
Okay, so we will
Can I-
not vote on this one then.
Yeah, can I go ahead and put a Christmas tree bulb on this?
As long as you don't power it.
Why don't we come back with a motion to adopt all the fees as they are? But one of the things, as you know, is a long-term project, I'd like for us to revisit all of our fees, understanding a fee is a cost recovery, but sometimes there are good policy decisions why you wouldn't want to subsidize those fees and keep them down, like the landfill or things like that. But there are some fees, I think, whose time has come to look at maybe increasing.
Okay,
So come back, we'll get all the fees adopted, get Josh's done, and then part of the work program for the next fiscal year is to look at fee structures. In my mind was in ramping up for the next year's budget.
Yeah, it's not a bad idea to make it sort of an annual rite of passage that we adopt that year's fee schedules.
And
Should we do that as part of the budget?
that's what I was
Yeah,
thinking.
I was thinking that precise thing, because we adopt and reordain all that stuff as part of the budget, so we can do the same thing with fees.
Yes.
Okay. All right,
So we'll come
so
back.
we will not deal with that
We'll
tonight.
go ahead and prepare, I guess, some type of fee schedule for public hearing. We'll bring that to you at the next appropriate meeting, once we get that. Here's our schedule of fees.
Do all of them, Josh, just put them all together. So
Yours, we're gonna have landfill, we're gonna have building officials, we'll have library fines, we're gonna have every fee.
You're gonna pick the full spectrum of fees in the county for this.
Absolutely, and this will be an
Okay.
omnibus fee schedule. And then you would re-adopt those fees as part of your budget omnibus.
And if we adopt those fees as an ordinance, so one of the things we can do is we can stick it in, on the back of the county code online, and then people can
You
actually
see 'em.
Okay,
see it there too.
But
All right.
I wanna, there's some fees there that need some discussion.
okay. All right,
That sounds like a task for.
anybody else has anything else to bring up? I would look for a motion.
I would enter a motion that since there is no further business, that we retire for the evening.
Okay, I have a motion to adjourn, do I have a second?
I would second that.
All in favor, say aye.
Aye.